Thanks you all for signing up for today's webinar. As Chris mentioned, we're going to be discussing the topic of telework. I'm going to offer some tips in 4 different areas and to see if we can answer some of your questions relating to telework. Questions we'll do at the end of the webinar, but feel free to use the chat function to put forward any questions that you want. So, oh, and also, if you find today's webinar helpful, and I hope you do, we're going to be hosting some additional office hours presentations beginning in early 2021, some timely topics, COVID vaccines and the workplace, the new Virginia permanent COVID workplace safety regulations, and also a host of new Virginia employment laws that were new to Virginia in 2020. So stay tuned for those announcements, and I hope you sign up for those as well. So, in many ways, sorry, we may be having a sound issue. Is that what I'm hearing? In many ways, it feels like an eternity ago when COVID began to have an impact on public health and on our businesses. In March, Governor Northam declared a state of emergency in Virginia to prepare for and deal with the public health threat posed by COVID-19. And by the end of March, had issued a stay-at-home order, essentially shutting down many of our businesses. Now, as we are approaching the end of 2020, we're starting to see a little bit of light at the end of the tunnel, it feels like, especially with the COVID-19 vaccine coming out this week. So we are very optimistic heading into 2021 that we're going to see some real improvements there. But at the same time, it's becoming very clear that that COVID-19 pandemic has permanently changed the way that many of us do our work. One of those changes is telework and how much we've come to rely on it, and we'll continue to use it even after we can look at COVID-19 in our rearview mirror. A recent survey of Virginia, Maryland, and DC employers that was conducted by the Metropolitan Washington Council of Governments showed 2 significant trends in particular for telework. And we're going to utilize some poll questions today to see if we can sort of gauge where you are with this and maybe learn some interesting stats. So we're going to go to poll question number 1 here. Okay, the first question is, what percentage of District, Maryland, and Virginia employers utilize telework for all employees on all work days since the pandemic began? We'll give you a minute to put your votes in. Okay, and we're all set. It's interesting, so 40% of you said 31%, 11% got 10% of the vote, 51% of telework got 50% of the vote, and 4% didn't gather any. So interestingly, the right answer is 51% of employers have been using sort of full-time telework since the pandemic began, and for some, it's been a matter of necessity. It's the way that you need to do that in order to continue to do business. For others, it's been a matter of expediency, and in many instances, has worked out really well. So we're going to do a second quick poll question that's related also to the Council of Governments survey. And so here it is on your screen. In the post-pandemic era, what percentage of DMV employers expect to use more telework for more employees over more work hours than pre-pandemic? Okay, And so we've got the right answer was 37%, and we've got a 67% right. You guys are right on top of your game. So really what it says is there are two trends that we're seeing that we think are going to continue for telework. One, it's become much more prevalent among employers. And two, that prevalency is going to continue even when it's not driven specifically by COVID. So there are many advantages created by telework, then that's both for employers and employees. For employees, the advantages of remote work are not insignificant. It results in time savings and flexibility in structuring the workday. Means may mean more time to sleep, to spend with their families, and as somebody pointed out in a call I was on yesterday, to spend more time with their newly adopted pet, or to focus on some personal enrichment outside of work with the additional time. Also means less time spent on stress, less time, less costs related to commuting to and from the office, and those are not small, small advantages. For employers, the gains of remote work are significant as well. Reduced overhead and operational costs are primarily a driver there. Less office space is required. And I'm sure many of you are finding that. I know a number of my commercial leasing colleagues are working diligently on reworking commercial leases to sort of downsize those to the extent that that's possible. Also, for employers, telework can be a recruitment tool to attract new employees, especially with highly educated or advanced degree employees. It seems to be much of the work there can be committed to telework, and it seems to be particularly attractive. And also, too, it can increase the size of your overall labor market with no commute to sort of bind where you can, recruit applicants. Sometimes it makes it easier both to increase your applicant pool and to perhaps reduce your overall hiring costs. So given all those advantages, and there are many more of those, but those are the highlights, telework also creates some challenges and some legal risks for employers at the same time. And so we're going to talk about four different topics today, and I'll try to give you a takeaway or two for each of those. The first one, the ones that's at the top of my list, and I think well justified, is timekeeping for remote work. And it's particularly important because the wage and hour laws, as many of you know, come with pretty steep penalties in the event that you get timekeeping wrong. So when we're talking about wage and hour, we're really talking about the Fair Labor Standards Act, a federal law that covers minimum wage and payment of overtime. Virginia has a brand new wage payment law that also requires timely payment of all wages that are due. And when we're talking about timekeeping issues for remote work, we're typically talking about exempt or hourly workers. I mean, non-exempt or hourly workers, apologies, but there isn't any reason why you can't require timekeeping for your exempt employees who are working remotely. So just a brief primer on the Fair Labor Standards Act. It requires that employees be paid for all time worked. And that also includes work that is not requested, but that the employer suffers or permits. So that means essentially work time that the employer either knew about or should have known about if they had been paying close attention. So it doesn't take a lot to figure out that this suffered or permitted concept gets a little dicey in the context of remote work. What does that mean, and how are you supposed to know when your employees working remotely are actually on the clock, or whether they're doing other things that really aren't related to work time? Well, the Department of Labor that interprets the Fair Labor Standards Act gave employers a bit of a lifeline recently. In September, it issued a field assistance bulletin, which is kind of formal guidance from the Department of Labor as to timekeeping issues for employers who have remote workforce. So the Department of Labor started from the basic premise that employers are required to exercise reasonable diligence in tracking teleworking employees' hours of work. And so the question is, well, how do you do that? And what's reasonable diligence? According to the Department of Labor, it is providing employees with a reasonable time reporting procedure And that's both for what you would call reportable time and also for non-scheduled work time, work that you didn't really ask for, but that your employee worked anyway for various reasons. You should do that in writing, your time reporting procedure, and be sure that you have your employees acknowledge that they've gotten it. The takeaway in this section is really that you really should pay your employees for all time that they report under your timekeeping policy. Do not discourage or put any barriers in the way of employees reporting their time worked, even if you didn't want it and even if you didn't authorize it. So pay the time and then deal with the employee if it's a serious enough problem through the disciplinary process if that's what you think is required. But do pay for the time. And if you establish a clear timekeeping system for your remote employees, you can build in a layer of protection for you in the event that an employee comes back to you later and says, hey, wait a minute, I didn't get paid for that time that I didn't really report, but you should have known that I was working. So let's move to the next topic, which is the Americans with Disabilities Act and telework as a reasonable accommodation. So we've got another poll question here, and we'll put that up on your screen now. And it is remote work considered a reasonable accommodation under the ADA? Okay, and the answer is 50% of you said yes, 20% of you said no, and 30% said not sure. And for purposes of our discussion today about remote work, that is just about right. It's just about where you need to be. So is remote work a reasonable accommodation under the ADA? The EEOC says yes, it may be in individual situations where the employee's disability prevents them from successfully performing the job on site, or job parts can be performed at home without undue hardship to the employer. That is, without significant difficulty or expense. But just to be clear here, the ADA does not require employers to offer remote work to all employees. In other words, the ADA is not a sort of work from home statute. It is something that you would have to consider as a reasonable accommodation for an employee in an individual disability situation, but it's not a general requirement under the ADA. Now, in the pre-pandemic world, ADA accommodations were easier, clearer. You just utilize your interactive process and play that out to determine what the employee's disability was and what accommodation would be reasonable under the circumstances. Post-pandemic, COVID-related remote work accommodations requests have gotten a little bit murkier, and the answers so far are not quite as clear. And here are a couple of examples of questions that clients have been fielding in the pandemic environment. Example one, employee says, I would like to work remotely because I have an underlying health condition that makes me more susceptible to medical complications if I'm infected with COVID, which is more likely if I come into the office. And the second example is, I would like to work remotely because I have a family member with an underlying health condition that makes them more susceptible to medical complications if they are infected with COVID. And I'm more likely to do that to them if I come into the office. Okay, so in the case of example number one, the best answer we have right now is maybe. Maybe yes, maybe no, that you would want to provide an accommodation there. And I'll talk about the one federal district court case from Massachusetts that gives a little bit of an idea about how this might play out. But we're still too new in the current environment to determine exactly how this is going to play out. Excuse me. For example two, however, the EEOC has said in its COVID and ADA guidance that, for example, two, the answer is no, that situation would not be covered under the ADA in an accommodations setting. So the court decision is Federal District Court in Massachusetts. The employee had asked for remote work as an accommodation to an underlying medical condition. They were concerned if they came into the office that they would suffer some medical complications if they were infected with COVID. So the court went through an interesting analysis. The employer said no, and the employee sued, and the court found that the employer was not entitled to a summary decision, that the matter had to move forward on the employee's claim that they were denied a reasonable accommodation of the underlying medical condition, making them more susceptible to COVID. I think what was driving the court's decision here, and I don't know how widely spread this is going to be, is twofold. One, that the employer did not engage fully in the interactive process with the employee to determine whether there were other options, partial remote work or some other accommodations that would have assisted this particular employee. Really, when it came down to sort of offering additional accommodations to facilitate the employees continuing to work in the office, the employer was viewed by the court as just not offering very much. So the court said, yeah, this is a serious situation, and we think that the employer had an obligation to do a little bit better than this as far as engaging in the discussion with the employee about what might work. So there you have it. That's what we know at this point about the telework as an accommodation issue in the COVID-19 environment. The bottom line and the takeaway on this topic is that you have to engage in an individualized assessment of any employee request to you for remote work or any other kind of accommodation through the interactive process. Always consider alternatives. If telework is not an option, will additional PPE protections in the workplace assist? Are there other options outside of that? Leave of absence, something. Even if you think ultimately you know what the answer is going to be, engaging in that process is really important to covering your legal risks in this environment. Just a quick note for employees who are already receiving accommodations in the office, they may also be entitled to those same accommodations or similar accommodations while teleworking. And again, for employers, the interactive process with those employees really is the key. Virginia employers have an additional sort of overlay of the new Virginia Department of Labor and Industry COVID workplace safety regulations. There really has not been any feedback on this front so far, so we can only sort of guess at what the regulations say. But basically, it's this: employees can refuse to work if they have a reasonable belief that they are in imminent danger. In other words, that they have a reasonable belief that there is a threat of death or serious physical harm that is likely to occur to them immediately or within a short period of time in the workplace. And these are COVID-related risks. So the employee has to have a specific fear of infection that is based on fact for the particular workplace, that there's some risk factor in the workplace that elevates the risk of infection. It does not cover a generalized fear of contracting COVID-19 infections in the workplace. And that is a fairly common thing that you hear from employees. I mean, we all understand that, as human beings, but that does not mean that in a sort of generalized fear environment that there are specific legal protections for that. So we are going to move on to the next section, which is harassment and other online bad behavior during remote work. And no discussion of this section would be complete without at least a mention of a recent incident of alleged bad behavior in the remote work environment. From the CNN headline, Jeffrey Toobin fired from the New Yorker after exposing himself on a Zoom call. Toobin is alleged to have unintentionally exposed himself to colleagues from the New Yorker and WNYC during a Zoom call. Rightfully, that caused many participants on the call some offense, and there were complaints. So the employer's obligation here is familiar to many of you. Title VII of the Civil Rights Act and the Virginia Human Rights Act prohibit discrimination in employment based on sex, race, and other protected characteristics. Hostile work environment is a particular kind of unlawful discrimination that involves unwelcome conduct because of sex or race or other characteristics that is severe or pervasive enough to alter the terms and conditions of employment. And there is a basis for imputing that liability to the employer. So the takeaway here, this is probably a presentation in and of itself. The takeaway from this section really is, you already have an EEO policy in your employee handbook. Be sure that you, if you haven't done it already, that you tell your employees so that they understand that your EEO policy, and indeed all your employee policies, apply to them while they're working remotely. There are no free passes attached to remote work. If you receive a complaint of harassment or bad behavior relating to remote work, do what the New Yorker did. You have an obligation to promptly investigate complaints of harassment based on hostile work environment. You have an obligation to take appropriate corrective action based on the outcome of the investigation. In this case, the New Yorker investigated the complaint against Tubin and fired him. So again, the takeaway, be sure that your employees understand your EEO policy is applicable to them in the office and when they're working remotely. So next, we're going to switch over to written telework policies and whether there are advantages to having a written policy or disadvantages. So we've got a couple of poll questions here, just kind of take the temperature of where attendees are as far as written telework policies are concerned. So our next question is, of the employers who have at least some telework employees, what percentage do not use a written telework policy? And this question is from a recent survey that was taken by by a national polling outfit. And the answer is, the answer is 25%, which 22% of you selected, 61% seem to be the most popular. So about a quarter of employers are not using a written policy for telework. And that's okay. There isn't a legal requirement that you have a written policy in place. The real question for today's discussion is, should you? So here are some considerations, that you may want to take into account for a written telework policy that you do have in place, or if you don't have one and you're considering it, here's a little bit of a roadmap for you. We have written a number of telework policies for clients over the past 9 months or so, and answered a lot of questions, obviously, on telework policies and what this all might mean. The first thing that I think is really important for you to do is be sure that your employees understand that telework is a privilege and that it's not a right of employment, so that it's clear that that if as the employer you decide that telework is no longer working for you and your business model, or that you don't think it's working for this particular employee, that you can end it, that it's not a contractual right. You want to define which of your employees are eligible for telework, and that would mean typically that employees who have been successful or better in their most recent performance evaluation certainly would not be applicable to employees who are on a performance improvement plan, for example. You want to set out the process for your employees requesting telework. If it's not applicable to all employees, it's important for employees to know how that process works. Also, to be sure that you convey that there is a separate process for requesting telework as an ADA accommodation. Importantly, you want to define both your expectations as an employer and what the employee should expect while teleworking. And that would be, again, the big one, your timekeeping requirements. If you're keeping and requiring regular work hours, what those are, employee availability during regular work hours. And we struggled a little bit early on. We were thinking about this as a law firm, sort of how we described this. And so we kind of settled on employees who are remotely working need to be available to the same extent that they would be if they were working within the office. So, I mean, again, that's a little bit of a squishy standard, but we felt like that was the best that we could do. And it sets at least some benchmark for, what employees' expectations should be, and they understand yours. Work location requirements. I had primarily been focused on remote work as, your employees working from their home. I had a call recently with an individual who said that they were really looking forward to, remote work, which they had requested, and that they were going to, enter into, an Airbnb rental for the next 6 months and work remotely from some exotic location, since it didn't, remote work didn't require them going into the office. And so, you may not find that problematic, but just be aware that knowing where your employees are working remotely can be beneficial, because there are some circumstances under which remote work from a different jurisdiction could render a different state's employment laws applicable, just depending on the circumstances. The example that comes to mind is California, which, as many of you know, has employment laws that are well outside of the norm and could set up some difficulties. So also define how you're going to reimburse telework expenses. Sometimes they're not significant, sometimes they are, and you just want to be clear with your employees what to expect, so that there aren't any sort of unfulfilled expectations there. The big reminder, all relevant employee handbook policies remain in place while teleworking, and confidentiality and security for all confidential and proprietary data, which is particularly important for those of you who deal extensively in PII and PHI. This is significant, what your technical requirements are for employees who are working away from the office. So I'm happy to take questions. And again, if we do not get to yours today, or you would just prefer to ask it offline for lots of different reasons, my contact information will be posted here. Feel free to reach out, and I'll be always happy to hear from you and see if we can answer those questions. So,
hey, Doug,
yes,
we did get a few questions that came through the chat. So okay, if you've got a moment. All right, actually, the first one was when you were speaking about the timekeeping. And does that apply for non-remote workers as well, what you're referring to?
Well, it can. I think most employers would have a timekeeping policy for hourly employees that would be relevant for work. The only question is whether there is anything different that might be required for your employees that are working remotely. The difference is, it's difficult. The lines are kind of blurred between work time and not work time, especially in the remote setting. So I think the important thing is the Department of Labor is sort of given a sort of roadmap, if you will, is be sure that you are clear with your employees what your expectations are as far as their timekeeping is. Define what you think work time is. Excuse me. It involves things like computer setup, computer sign off, things of that nature. Be sure that you pay your employees for the time that they work. If there is a need to take some corrective action based on what you find your employees doing remotely, do that, but don't withhold pay because you think that they worked without authorization.
Okay, great, thank you. We have another question, and someone was wondering if you have any recommendations on user-friendly timekeeping programs.
That is a very good question. I don't, but maybe we can post some links on our website, or if you reach out to me directly. I'm reluctant to recommend one particular product because it may depend on your particular business model. But what I would say the important thing is, no matter what kind of timekeeping program you use, or even if you decide to do it with something as simple as an Excel spreadsheet, which it certainly is acceptable, is that you be sure that you have your employees verify the accuracy of the time that they have submitted, because that really is your, protection in the event that claims come up in the future. It happens all the time that an employee has worked additional time that they essentially didn't put in for because they didn't think you wanted them to, or they didn't think that you'd let them do it, or things of that nature. But be sure that you have them verify this is all the time that they worked.
Great. Here's another question, Doug. So you commented pay employees for time worked. How does this apply for remote workers who decide on their own to work in the evening versus typical business hours? Are they entitled to shift differential rate of pay?
Well, I think that would depend. Shift differential would be for a couple of different reasons. If, as an employer, you have a shift differential agreement with your workforce, then it would apply. I mean, if it's a contractual arrangement, then you would have to honor that. But aside from that kind of a collective bargaining agreement would be another example. But aside from contractual arrangements, after hours work time is compensable at the same hourly rate that sort of in sort of regular work time would be compensated at. Really, there are two things that you're trying to accomplish here. One is to be sure that you're capturing all of the time, both during regular work hours and after hours work, that your employees are engaging in, because you have to pay them for that. And so you want to head off the possibility that they're not reporting after hours work in a way that, without the protections that we've talked about today, could come back to haunt you at some point later.
Great, thank you. Another question was, do you happen to have a draft or a sample telework policy that can be shared?
I think we can provide the basics of a telework policy. There, it's like a lot of agreements, that there are some sort of boilerplate provisions that you'll want to have in your policy, but there are also a number of specifics that you'll want to have that are tailored directly to your particular business model and your workforce. But Chris, I think we can probably post a sample perhaps to our COVID-19 page on the law firm's website.
Okay,
might be
great.
a way to do it. Or if the questioner can reach out to me after we're finished up, I'll see what I can do to get a template. But really, the important thing is to be sure that any telework policy fits your particular business model.
Super. I think that's it. And I think we've gone a few minutes past the 30 minutes, but this was great. Thank you so much, Doug. And thank you to everyone who joined us this afternoon. And as Doug said, if you have any additional questions, you can reach out to him. His contact information is there on the screen. And thanks again. So I hope everyone has a great afternoon.
Thanks, everybody. Happy holidays and Happy New Year. Looking forward to 2021.
Yep.
Take care.
Thanks, Doug. Okay, bye.